This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions about car, truck, and motorcycle wrecks. Call in your questions. Maybe you'd like to know about the first things you should do if you've been involved in a wreck. Maybe you've got questions about insurance. Maybe the other driver's at fault, but they don't have insurance. What does that mean for you? Does that mean you're going to wind up having to pay the bill? Maybe you're experiencing pain and it's several days or weeks after the accident when at first you said you were fine. Does that mean you don't have a case? Call in your questions. 31 Law Call number 256-536-0077. You can also email a question. You can email to lawcall@waaytv.com. You send in an email any day of the week on any legal topic. And when we get to a show that's on point, we will pull some out. We will have some of your email questions tonight. Getting us started tonight, Will League is here from Timberlake, League and Brooks. Good to have you here.
All right, Sharon. Good to
Police,
be here. You doing okay?
Car, truck, and car, truck, motorcycle accidents. You know, one thing people always are worried about, if the police report is not in your favor,
right.
What can you do about that?
We were talking about the police reports earlier,
Yep.
you know, and let's say we're in a wreck, I give a statement, you give a statement, and if anybody out there has given their statement and the police report been against you or for you, give us a call and let us, share that story. And we're going to talk a little bit about, whether or not the police report itself is admissible to determine who was at fault. Sharon, they'll come, get your statement, my statement. Sometimes the officers will just say, you know what?
It's your fault.
Due to conflicting statements.
Oh.
The officer doesn't know who's at fault.
Okay.
But even if he says I'm at fault in our wreck, that police report in and of itself is not admissible into court. And so unless the officer saw the wreck, he can't testify as to fault, as to what happened. Now, what they can do is testify as to, okay, I saw 17 feet of skid marks. I saw the door hanging here, or there was a hubcap here, and take measurements. Those are fact scenarios, excuse me, that he or she can observe on the scene and take those measurements. And to take a step further, if you're going to use expert testimony, you have to have certain scientific training outside just the layperson, the average Joe out there, making a claim as to he or she thought this is what happened during the wreck. You have to have their credentials to come in and say, I'm a certified accident reconstructionist, and take those measurements, whether it be crush analysis of the vehicle, when you start getting into all types of physics, or the other type of, how fast, what the velocity of the vehicle is based on these skid marks and all those measurements and the weight of the vehicle, determine speed, length, all those things. And so, the police report in and of itself is not admissible, but sometimes the facts observed can be, if they're documented properly.
Call in your questions, 536-0077. Before we get to questions, we've got tonight's You Make the Law Call. We pull some video from Facebook or YouTube. This guy, he's crossing the road.
Man.
Okay, didn't see that happening. The dog takes him out. And it doesn't look at first like this would be a big injury, but he's still holding his back. That makes you think.
He's coming, so, let's say we're in Alabama or somewhere else. Okay, is he looking both ways? Is he doing what he's supposed to do? He looks, he doesn't see a car there.
Yep.
Okay, here he goes. Man, that's tough. That's tough.
Dog's moving fast.
And the older you get, it's harder to recover from injury, from falls like that. So, all right, let's say we're in Alabama. In the city, is there a leash law? So the dog can't be, can the dog be liable in and of itself? The owner could be liable if there's a leash law. You're supposed to keep your dog up. Now let's take it a step further. These first bites free rules, to where if your dog bites someone and you didn't know about it, didn't know there was dangerous species, you might not be liable that first time.
Okay.
In this case, was the dog escaping often? Were you doing what you're supposed to do to control your animal? And you could be liable for that. You saw the guy was hurting, things like that. Now, the question is it recoverable? Is there insurance behind it? Does the dog owner have assets to pay your medical bills and things like that? Do they have insurance? So those questions need to be asked if you file a claim against the dog owners, for your injuries, medical bills, things like that. Getting a judgment proving that the dog did it and you were responsible is one thing, but collecting on that judgment's an entirely different thing.
Yeah, at least they've got some video to show.
Right, we're
Can't
seeing
you
more
believe
and more. We're seeing more and more videos in cases we're trying.
Yeah.
And it helps to try our fact, helps the jury and the judge.
Can you imagine if you didn't have the video trying to tell people, well, this dog ran out of nowhere? Sure.
I had a case one time, a guy's going on his 10-speed, 10-speed, that shows how old we are, road bike, and he's flying down the hill and the dog comes out and he hits the dog, messes him up real bad, couldn't find the dog's owner, it was a stray. and nothing you can do.
Nothing you can do. We've got callers waiting. We've got Ruben on the line with a question from Huntsville. Hi, Ruben. Thanks for calling. What's your question tonight? Hey, Ruben from Huntsville, are you with us? What's your question tonight? One more time, Ruben? Okay, we'll see if we can come back to Ruben. We always invite you to send in email questions, and we got this email question from Jess. Jess wrote in, my cousin was killed when his motorcycle hit an SUV. It's been suggested that my cousin was speeding, but the driver definitely turned in front of him. If they can somehow prove that my cousin was over the speed limit, does that mean that his family has no claim against the driver? First off, Jess, we're sorry about your cousin.
Yeah, that's right. That's right. So we're going back to contributory negligent law in Alabama. And all right, the defendant driver pulled in front of somebody on a motorcycle. The motorcycle rider was killed. The question is, okay, who had the right of way? Usually in these cases, well, let's assume the motorcycle had the right of way, that the other driver turned in front. That's failing to yield the right of way. That breaches, that violates the law. That driver would be responsible, however, or would be liable. Then the question becomes, was the motorcycle speeding? And if the cycle was speeding, contributory negligence could argue, okay, there could be an argument of contributory negligence if the motorcycle was negligent, him or herself, and actually contributed to this wreck, because had they not been speeding, they would have been able to either avoid it, or there was enough time for the car to go.
Okay. And
that puts it into somewhat of a gray area. Unfortunately, even if they're at fault even a little bit, there cannot be a recovery against the defendant driver. Now, Alabama is unique in that particular law. Georgia, Tennessee, comparative negligence states, Florida.
Okay.
So the level of your conduct has a determination as to whether or not you can recover for your, for your medical bills, injuries, property damage, things like that. And it really cuts hard when it cuts against you.
Yeah.
And
so in Alabama, if the jury decides you were contributory negligent, they can't give you anything.
Not a cent. So let's say you barely, you were going 56 and a 55, and you were clocked, and they was able to prove it. Were you negligence per se, meaning you violated an outstanding, a law that is in full force and effect. Okay. So under the law, you wouldn't be able to recover. And the juries are charged with that particular jury charge. Okay. They'll go back, ladies and gentlemen, if you find that the plaintiff contributed to this wreck in whatever fashion, then you cannot rule for the plaintiff. And that's a pretty harsh law.
That's tough. So if it happened somewhere else,
states that still has it.
If it happened in Tennessee or Georgia, then the difference is what?
Let's say the motorcycle rider was 10% at fault.
Yeah.
Then he or she will be able to recover 90% of the damages, and the other driver gets relief for 10%.
Seems more reasonable.
Right, it does. It does, to kind of just make it go along with conduct as opposed to just an arbitrary, you're totally out. And I think it's an insurance company-driven law.
Okay, let's talk a little bit about first steps. If you're in some kind of an accident, what are the first things you ought to do? Of course, get help. Get help for anybody that needs help. But as far as being able to recover later if you needed to, are there some things that you need to be taking care of? Do you have to gather your own evidence?
Well, so the evidence is right there. So once the wreck happens, oftentimes the other driver will want you to move your vehicle. And I had a case just last week. Driver comes up and lunges in my client's car trying to get her cell phone. It was so crazy.
Really?
Yes. So they was rear-ended. Other person comes up, was intoxicated, tried to get him to pull off the road, and then lunge for the cell phone. They're on 911, and it's crazy.
Gee.
It's crazy. So ordinarily, and if I would not advise you to move your vehicle and let the officer come and evaluate and do their diagram. Now, if you're on 565 and you're in the middle lane and you can safely get over, do that, because it's not worth getting killed inside your car.
Yeah.
But we recommend trying to get photographs of what's going on. In this particular case, the lady got out and took a picture of the tag of the other lady who lunged for her phone. And she left. She fled the scene. So you want to try and get evidence, that way if you can. Make sure everybody's safe. And I've had juries say, well, I'm glad you had those photographs. They really helped us. And I've had juries say, well, she was planning a lawsuit by even taking those photographs. So,
oh, really?
So I was surprised to hear that from the jurors, because it gives them a clearer picture. But we tell folks, if you can, save evidence if you can safely. You want to make sure to give your full version to the officer. We'll ask people in depositions, did you have the opportunity to talk to the officer, give your side of the story? Because it's not uncommon when the defendant driver has all of a sudden they get repped up, get an attorney, all of a sudden their story changes as to what happened, and that's a shame. But you want to make sure that you're clear with the officer if there's time to be. And second is document your injuries. Make sure you take care of yourself. Make sure you're trying to get the treatment to not only get better, but to, because as you talked about, oftentimes things don't manifest themselves till later.
Yeah.
So you want to get checked out and make sure adrenaline's up and people don't know.
Yeah.
And they're kind of tough at the scene. Then all of a sudden things settle down. Then things start happening.
We've got Gail on the line with a question from Danville. Hi, Gail. Thanks for calling. What's your question tonight? Gail from Danville, what's your question tonight? Having a little trouble with our phones tonight. One more try with Gail. Hi, Gail. Thanks for calling. What's your question tonight? Nope. Okay. Let's talk about if the other driver has no insurance and you think they're at fault.
Right.
What happens to your case?
All right, so we get a lot of calls about having other driver not having insurance.
Yeah.
What can be done? Now, it's a law in Alabama to have liability insurance as a minimum. If you don't have it, your driver's license can be suspended. You can't register your vehicle if it's done in the proper channels with the Department of Revenue. All right, so let's say someone hit Sharon Doviet. They don't have insurance. Now, there's a couple different types. Let's say you have liability only.
Okay.
So it would not cover, unless they didn't have, your insurance would not cover your vehicle. So you would not have coverage. Now, you could file a claim in a court of law against the other defendant driver, get a verdict, and you'd have to recover or collect that verdict, which you could do, but it's going to take you, a long time. You would rather have your insurance company address your property damage, whether it be a total loss or getting the vehicle repaired, and then they can in turn go against the other driver if you have just property damage. Now, if you have personal injuries and all you had was liability and they had none, you're underinsured motorist, you wouldn't have it, so it wouldn't cover you.
Okay.
And so what is uninsured motorist? It basically insures you against another driver who does not have either A, insurance coverage, or B, enough insurance coverage to cover medical bills, lost wages, things that you need if you're out of work for a period of time, and any type of injury that you sustain in that particular wreck. And so make sure to look at your insurance policy, because you see the commercials about only get what you need, but you don't know what you need until you need it. And so they're a bit disingenuous, and I get it, you want to save money, but underinsured motorists is some of the cheapest insurance to get, and it insures you against an unknown risk. And you have to actually sign a waiver to to waive that coverage. Alabama law requires your insurance company to offer that coverage, and you have it unless you sign an explicit waiver that you have it. And it's so important that there's a law saying you actually have to sign it away.
And if you didn't, you've got it.
That's right.
Okay.
That's right. And it's very important insurance to have. And anytime you go, talk to your insurance agent about it.
We're going to take a break. Be right back answering more of your questions about car, truck, and motorcycle wrecks. Stay with us.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of attorney Michael Timberlake, attorney Will League, attorney Heath Brooks, attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions about car, truck, and motorcycle wrecks. Will League is here from Timberlake, League & Brooks, and we've got callers waiting. We've got Gail on the line with a question from Danville. Hi, Gail. Thanks for waiting. What's your question tonight?
Thanks, Sharon. My girlfriend was involved in a wreck, and about 5 weeks previous to the wreck, her insurance agent had switched companies for her. And everything was the same. It was supposed to be automatically deducted from her checking account. Well, somehow some numbers got messed up. I don't know if it was the routing number or the account number, but that money was never taken out of her checking account.
Gotcha.
And the policy was canceled, unbeknownst to her.
Okay.
So she got in this wreck and finding she doesn't have insurance.
Oh, okay.
Oh, man.
What do you do with that?
couple things. So there's protocol for canceling insurance. We'll look at your policy, see what their actual policy is to determine, when it was canceled, did they provide you X amount of days notice per the policy? And you may still have coverage if they didn't notify you properly. Then the next question becomes,
okay.
Go ahead.
Thank you.
Did they give her a letter or nothing?
No, we didn't know that she didn't have insurance.
Okay. There also, let's say the agent said, okay, he assured her that she's covered, and he just didn't call it in. Well, under the E&O coverage, the errors and omissions, she can make a claim with the agent himself, and the insurance company there may cover that particular claim if there was an error being made by the agent. Again, let's say there was an error. They can prove there was that conversation. I'm not saying it was, but then the question becomes, if it didn't, if the money was not taken out of the account, there was not a contract, then there may just be no coverage, at all if she just let it lapse, or was not put on notice, or was put on notice, properly, and then it was allowed to lapse. But in this situation, I talked to the agent and see if an E&O claim could be made. I mean, sometimes they can be quite expensive when you talk about the value of some of these vehicles if there's medical bills involved. Yeah. What type of damage was sustained?
Totaled.
Totaled? Oh. Is it? Let me ask you this: is it in a tow yard right now?
No, it's in a driveway. It was in a tow yard for a couple of weeks.
Right. Yeah. Go ahead. Good thing getting it out of there. You don't want to accrue all that if there is not going to be coverage. What about? Is there a lien holder on the vehicle?
Yes, there is a loan on it.
Okay. You may want to contact them sooner rather than later. They may want to get the vehicle and move it to either have it evaluated or storage, because again, they have an interest in that vehicle. And if is there a payment, then well, let me ask this: was it a single car wreck or was it just her?
No, she pulled out in front of somebody.
Gotcha. Okay, get with the agent and see if E&O will cover that. Absent that. Sadly, you'll have to make arrangements with the bank.
That stinks.
And it's just those simple, easy mistakes that happen to all of us. Yes. A letter comes in, you don't see it, it stays in the pile for a while. Yeah. Next thing you know, you don't have coverage. Yep. We hear that story all the time. Despite best efforts, it was canceled. But again, there's ways procedures they have to follow to cancel properly.
We've got Shirley on the line with a question, I think from Huntsville. Hi, Shirley. Thanks for calling. What's your question tonight? Hey, Shirley, are you with us? One more time. Shirley, we heard you before. Shirley, you're there. What's your question tonight? Okay, let's talk about third-party things. So take riding a bus, taking a trip on a bus, taking a trip on school buses. And we had the Tunica bus. We had the school bus accidents. When you're riding with somebody else, how does that complicate things?
You've got a common motor carrier. There's an extra level of protection, or at least there should be. In the 18-wheeler cases, and we handled the Lee High School bus wreck cases, for those who remember that way back when, and the Tunica cases, and the school going to Atlanta years ago. And you need to have, you're supposed to have a pre-trip inspection. We're supposed to have a heightened a driver with heightened education, whether it be a CDL or going through training to actually be a common motor carrier. He or she has enough sleep. The alcohol threshold is 0.02 and below, or below 0.02. So it's supposed to be, much safer in terms of your driver qualifications, all those things. And unfortunately, if some of those steps are missed, one case we had the tires were bald, the driver was speeding, we're in snow, and then here we go. And a lot of people lost their lives. It was horrific. 18-wheeler wrecks are similar in that there has to be a pre-trip inspection. You're keeping logbooks, determine where the truck's been. We're not seeing as many doctored logbooks as we did in, say, the 90s. Everything's computerized, so it is, much safer, I will say, in terms of driver readiness. We're not seeing what we used to see, two sets of books, and all of a sudden you find out a driver's been up for 7 days, and it was just awful. And so, again, but when you're talking about heavy trucks, the velocity and the power behind those things, we see a lot of death cases because just the sheer weight and speed involved.
Hard to stop them. Mm-hmm. We've got Ruben on the line with a question from Huntsville. Hi, Ruben. Thanks for calling. What's your question tonight? Hey, Ruben, are you with us? Okay, let's talk about if you're riding with somebody else. Let's say you are riding along with a friend, or borrow somebody's car. Talk to me about the differences with that.
We talked a little bit about, okay, when we were kids, remember your parents saying, you know, if you let somebody borrow your car, they'll sue us for everything we got.
Right.
And here we
Is
go.
that true?
Well, they thought it was, but it wasn't.
Okay.
And so for the parents to be liable, you have to show that they did something negligent. For example, you know, 16-year-old, Dad, let me borrow the car. If he's walking out and he's drunk and you throw him the keys, then you could be liable for what's called negligent entrustment. You let somebody drive your vehicle that was intoxicated and cause damage, you're responsible for that. But normally, let's say the kid's okay, leaves the house and is negligent, him or herself, causes damage. The insurance on the vehicle is responsible up until their limits, and then it cannot extend past the child or assets he or she may have. They may get a verdict, but it would not extend to the parents in that particular scenario. So all things we heard growing up, that was not entirely accurate, but the insurance is first and then the assets of the particular driver. It does not extend to another driver unless they have some type of, another car owner, unless they have some type of fault.
Okay, let's talk about if you give somebody a ride.
Right.
If I let a friend ride with me and we have an accident, can they sue me? Are they going to sue me?
All right, so the theory behind this is we wanted to encourage people to give rides.
Yeah.
If, you know, and carpool, save energy,
yeah,
all that type of things. And so the law says, look, if you're going to be a good Samaritan and give somebody a ride, you won't be negligent, or you won't be liable for your sheer just negligence if you just make a simple mistake.
Okay.
Now, if you're not giving somebody a ride, you are liable for your negligence to that particular person. However, if you're wanton, if your conduct is reckless, intentional, or what we call wanton, you're engaging in conduct you know will probably going to get somebody hurt, then you're not immune from that type of damage,
gotcha,
you know, caused by that type of conduct.
Okay. We got an email question from Jim. Jim says, my car was rear-ended by a reckless driver from outside Alabama whose insurance company deemed my car totaled and provided a low-ball value. It's 20% lower than the market value. As my car has only liability coverage, my insurance company will not intervene. Should I hire a lawyer?
Oh,
they're lowballing you. What do you do?
All right, so the reasonable, I mean, how much is the car? How much is it going to cost? So you got a reckless driver from another state.
Yeah.
Their insurance company's lowballing. If you file that case, because that driver lives in another state, you probably have to file it in federal court, called diversity of citizenship, because you got people from 2 different states fussing. So you can't just go to their state or your state. You'd have to go to federal court, which may cost you a lot more in fees. So how much is your vehicle worth? Is it worth going after that person? If you got liability only, you don't have comprehensive or collision to cover your vehicle. And so that really puts you in a tough spot.
Go visit a lawyer and talk through it.
Yeah.
We're going to take a break. Be right back answering more of your questions about car, truck, and motorcycle wrecks. If you didn't get your questions answered tonight, here's how to get in touch with Will League with Timberlake League and Brooks in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And family law attorney, our own Sharon Dovey at Huntsville, 539-7337. SharonFamilyLaw.com, child custody and divorce. She does a great job.
Thank you, sir. Okay, if you can't afford a lawyer, you're dealing with these problems, can you meet with a personal injury attorney?
A lot of people think that you pay as you go. Usually when you're getting with an attorney, it's okay, here's a retainer and they work off that.
Yeah.
But in the plaintiff world, it's a contingency fee. They don't owe any money unless they're recovered.
Gotcha. Thanks for all your calls and questions, and we'll see you next week.